I think there's a function in Zoom where you can hit a button and kind of raise your hand, or you can type a question in chat and go from there, and I'll hopefully be able to answer your questions. It's a little hard to do interactive kind of teaching here, but I've been playing with it for the last couple of months, so hopefully we can make it work. I am here today to talk about the court process for dependency and neglect cases. It's good to see such a large class. I think it's been a while since we've had this large of class. Hi, Vicki. And so it's good to see that people are still volunteering and coming out to help kids. I am Howard Reinstein. I'm the Deputy County Attorney with Adams County in their Human Services Office. I have been with Adams County now for 31 years doing this work. And prior to that, I was a GAL for a while. I was a parent attorney for a while. So this has been juvenile law pretty much, and child welfare particularly has been my career since I have become a lawyer almost 35 years ago. So this is what I do. And I've had the opportunity and privilege of teaching CASA classes since the inception of the Adams, it was just Adams County CASA, now it's Adams Broomfield CASA, and been able to teach various classes about the legal issues, but particularly around how a case works its way through the system. So that's what I'm hoping to accomplish today. I've got some workers outside with a chainsaw, so hopefully I can hear and you guys can hear me. Everybody here okay? Everybody ready to get going? So normally I would try and interact with the class and ask for some sort of legal background, see if anybody's got any experience with the court system. With this many people on Zoom, it's a little hard to do that. So I think I'll just get right into the substance of the class and then let you guys ask questions, interrupt and ask your questions if you need to, or if you want to. And hopefully this will move relatively quickly and people will understand what's going on. So let's get going. I work for Adams County Human Services, and I don't know, I think you have someone from Human Services who comes and speaks to the class as well, but Human Services has, in the Child Welfare Division, has 4 separate units. It has an intake unit, an ongoing unit, a permanency unit, and then a client services unit. So they pretty much are self-explanatory just based upon their name. Intake receives and assesses and investigates all of the referrals that come into the county through the state hotline. And the state hotline works where they have a central location to take all the phone calls, and then they send them to the different counties to which they apply. So that's, the hotline was created 4 years ago, something like that. Before that, it was individual county phone numbers that everybody made their referrals to. Adams County receives, I think, pretty well over 10,000 referrals a year. It's probably closer to 12 or 15. I haven't seen the numbers recently. Things are, as I'm sure everybody could understand, a little bit weird right now in terms of how to respond to these cases and what to do, but they receive, we'll just go with the 10,000 number. Every referral that comes in to a county system has to be evaluated by what's called a red team. And it's not a, I don't know why it came up with red, but it's an acronym for not a very complex definition. It's review, evaluate, and decide. So it's a red team. And it consists of different members of Human Services Child Welfare Division, from managers and supervisors on down through workers. And they review every single referral that comes into the county and makes a decision about how to assign that, whether to assign that, what kind of response is required. And so they run red teams probably 3 to 5 to 6 times a day, or separate teams going on to where they have 5 or 6 teams at any one time when things get really busy. Things have unfortunately slowed down because kids aren't in school, they're not being seen by third parties right now. And so everybody in the field is a little bit concerned about what's happening with children out there, but they're doing the best they can with what they have to work with and the circumstances. So they review the referral, they make a decision as to what to do with that. There are 3 types of responses that Adams County has. They have an immediate response, which is 24 hours. They have a 3-day response, and they have a 5-day response. And each of those is based upon the nature of the referral. An immediate response, for instance, would be Children's Hospital making a referral because they have a baby who's got a spiral fracture to their leg. That would be an immediate type of referral. A 3-day response, at least in the old days, would have been a child showing up at school, looking hungry, has some bruises, we're concerned about it, the parents are not real responsive, so they go out within a couple of days and check into that and do their assessments. Of the 10,000 plus referrals that they get, they assign essentially around half, a little less than half of those for further assessment. And of those, we're filing, our office then takes those cases if they become court cases, which is a long-winded way to get to where you guys start to get involved. We file around generally between 375 and 400 cases a year. So we're not even filing 10% of what Human Services assesses in terms of cases. So they really work hard to get people into the community, to divert them to community or faith-based services. They work with families on a voluntary basis. They have a couple of teams that are designed to do just that, to try and keep them out of the court system, keep kids in the home, to get wraparound services that are more long-lasting than what Human Services might be able to provide. And so that's how they make those decisions. But what you guys are involved in are the cases that come into court, those 385 cases that come into court every year. And I'm going to primarily focus on cases where children are removed from the home, but that is not the majority of the court cases that we file. The majority of the court cases that we file, children remain in the home, or they go for a short period of time to kin, and protective orders are put in place, and the court gets involved, and Human Services stays involved to supervise and to provide services to a family to try and alleviate the issues that brought the case to the attention of the family. I guess Rachel got bored and she just left, but that's what seems to happen. And if anybody else wants to do that, feel free, that's up to you. And most of you who don't have your cameras on, I'll never know if you do that, so just go right ahead. So anyway, we'll talk today about the cases that require removal. Those are the more complicated cases. Although cases with kids in the home and trying to have a father have to leave the home for domestic violence purposes or issues, or a mother needing to leave the home, or somebody coming into the home to provide some assistance with the kids and implement a safety plan, those can end up being fairly complicated cases. But from a legal perspective, the cases where there's removal are the ones that are generally harder to deal with. So I'm going to go through how kids get removed from the home, for what kinds of reasons, and then we'll talk about the different steps in a case, try and identify where you guys get involved and start being a part of the case. I'm not going to talk about what your responsibilities are. That's up to other people to train you about that, and I'm sure they have. So just to be curious, where are you in your training at this point? Are we at the beginning, at the end, in the middle? Anybody can answer the question and just let me know where you are in the training.
We have a wide range. We actually have some people who just were sworn in, and then we have some veterans on the call as well.
Okay. Okay. So, yeah, you guys are probably in a weird circumstance, just like everybody else in the world right now. So I imagine things are a little different than they normally might be. So for the veterans, this may be a review of some things that you've already that you already know about, that you've watched in court, that you've been involved with. But I'm still going to go through it. It's never there's never too much training that you can have about certain things, and so it'll be a refresher for some of you, which is why at least some of the faces I see are familiar, because I've probably seen some of you in court already. So kids come into the custody of the department in 3 different ways. There's the voluntary placements where parents will ask for help and will ask, and kids need to be removed on a short-term basis while the department works with the family, lets the chaos in the home settle for a brief period of time. Generally, in those kinds of cases, kids don't go into the foster care system. There will be kin that can take those kids for a short kind of a respite period, or family friends, or somebody who can do that. We hope not to put those kids in foster care. And for the most part, those voluntary kinds of cases, any of you who have adolescents, and of course all of us were once adolescents, understand that the majority of those cases are going to be for adolescent kids. That kids just start getting out of control, parents start losing their minds over how to deal with that, and things are just heading down a rabbit hole. And so we need to make sure that kids stay safe, parents get the services they need to make sure that those kids do what they need to do, go to school, stop using drugs, those kinds of things. So we have some of those cases. And somebody just asked, before a child's removed from the home, are parents obligated to comply and participate? Yes, unless it's an emergency. So let me talk about the other 2 ways that kids end up getting into the custody of the department. One is through a police hold, and that's a situation where parents get home from the bar at 2 a.m, they get into an argument, it turns violent, the police are called, there's 2 young kids that are 3 and 4 years old that are hiding in the closet, and the police have to be involved. They have to separate the parents. One or both of the parents is going to be either arrested or taken to detox, and the kids need to go someplace, and the parents are either too intoxicated to provide any information about alternatives, or there aren't any, that they don't have any support in town, so they have no place to put these kids. So they end up contacting Human Services, and they are allowed to give custody to the department. We have to get into court within 48 hours if it's a police hold. So that's called a police hold. The other circumstance is a judge's hold, and it's a little bit less emergent. It's the kind of case that I mentioned where kids come to school, they're consistently dirty, they're consistently hungry, they're consistently tired, and then they show up and they have some bruises that weren't there the day before, and the school calls in a referral, and the department goes out and starts their assessment, and it turns out that the kids are reporting that mom's new boyfriend, who's moved into the home, is drinking all the time. Mom is using some drugs, or they see glass pipes and white powder, and she's drinking all the time, and they get into the arguments, and the kids get in the way, and they start not taking care of the kids or even physically abusing them. And the department recognizes that those kids aren't going to be able to go home from school because it's not going to be safe. So they contact the court, and the court's required to have a judge on call 24/7. They rotate that through all the various judges. and the judge can give what's called a judge's hold or a protective hold for kids to be placed anywhere that the department can find that's appropriate. So if kin can be found, custody might be placed with kin, but if not, then those kids will end up in foster care as well. And when that happens, that case needs to get into court within 72 hours for the court to review the situation. We have to make a decision as to whether we need to file the case or not, depending on the circumstances. And then the case moves through the court system. So to answer the question about whether parents need to participate or comply, they're generally not being asked to comply with much if it's an emergency like a police hold or even a judge's hold. But there are an awful lot of cases where the department will work with a family for a month or two, or at least a number of weeks, to try and prevent the filing and certainly to prevent the removal of kids from the home, because nobody wants to place kids. All of the research, everything that's ever been done in this field up to this point has recognized and acknowledged that in addition to the trauma that actually is taking place in the home, whether it's from physical abuse or whether it's from just the chaos and circumstances in the home, that trauma is very significant, but almost equally as significant is the trauma of being removed from the home and placed somewhere. So there's really a major challenge and push to not place children because it's not safe. I mean, well, it's safe, but it's only for safety. From the child's perspective, it's almost as traumatic as what was going on. And then you have those worst case scenarios where you remove children from an abusive environment and place them into another one that you didn't know was an abusive environment, and now you're traumatizing them even further. Now they have to be placed a third time. So it's something that the department works hard to try not to do, which is why they evaluate all the referrals, which is why there are a number of checks and balances and supervision and permissions that need to be obtained before kids can be placed out of the home. Obviously, except for a police hold when it's an emergency and it just has to happen. So once custody is obtained by the department, or even those cases that are protective order kind of cases, the next step in the process would be the filing of the petition in dependency and neglect, which is the legal document that we file with the court to open a case. And our office files that petition with the information given to us by the department. That petition contains the biographical information, birth dates, locations of parents and children if we know where the parents are, and it provides a summary of the facts of the involvement of the department that got them involved enough to want to need to file the case. And then it gives a recitation of some of the definitions of child abuse and neglect, and then it talks about the rights that families have and the consequences of potential termination, and it refers to the Indian Child Welfare Act, which we will get into in a few minutes. So that's how we start a case. And I just saw another question in terms of whether a petition for custody has ever been denied. Yes, there are judges' holds that have been called in and the court will say, no, you don't have enough to take custody. You need to figure something else out. It doesn't happen very often, but it occasionally has happened. And, you know, it leaves everybody sort of spinning and trying to figure out how to perhaps get those kids placed voluntarily with a family friend or a neighbor or relative, but it does happen occasionally. So once we file that petition, the next step is what's called a shelter hearing. And we potentially have shelter hearings every day, depending on what's coming into court. And again, things are a little bit weird right now. So they're trying to limit the number of cases that we can file every day to not overwhelm the court system. So shelter hearings are usually held in the magistrate's division, but everybody will do them. And just to fill in, there is one magistrate and two judges. And the difference between, if you don't know, and I don't like to say this with magistrates, but the reality is that a magistrate is sort of an associate judge. Is they have all the powers and responsibilities of a judge, but it's limited a little bit in terms of what kind of trials they can do. They can't do jury trials, and any decision of a magistrate is reviewed by a district court judge, whereas any decision of a district court judge is reviewed by a higher court, the Court of Appeals usually. So that's kind of the difference. Right now, we're only running one division a day, but normally there are 3 courtrooms that are going on, because the judges also and magistrates also hear juvenile delinquency cases. And there will be crossover cases that you guys might be involved with some of the older kids, the adolescents who have both dependency, neglect, and delinquency cases. So there will be some crossover that you're going to have to deal with. So at the shelter hearing, parents have the right to apply for court-appointed counsel, and those are called Respondent Parent Counsel, RPCs. There is a group of private attorneys who contract with the state to represent parents in these kinds of cases. And they are supervised by the Office of Respondent Parent Counsel, which is a state agency that was created about 4 years ago to monitor and manage those contracts and to supervise the contracts. The legal decisions are still made by the individual attorneys. So parents, if they're qualified, if they're found to be indigent, are appointed counsel in these cases if they request one. The large majority of our cases, parents are qualified and do or are eligible for court-appointed counsel, and they get that. And frankly, for the most part, that makes cases move a little bit more smoothly. As you can imagine, it's hard enough to negotiate this system if you have some background in it or experience with it, and you're not in the middle of having had your kids removed. So having counsel actually is very helpful for parents. We encourage it to happen because it just makes cases go a little bit more smoothly. At the shelter hearing, there's also a group of contract attorneys who contract with a different state agency who are appointed as guardians ad litem. And they are required to be lawyers in Colorado. Some states don't require that. A guardian ad litem is an attorney who represents the best interest of children. They don't represent the children directly like a parent attorney does or a defense attorney might, but they represent specifically the best interest of those children. So they independently assess cases, they work with the department, they work with families, they work with treatment providers, and they make independent recommendations to the court about what they believe is in the child's best interest. So they are also appointed at the shelter hearing. And there's a system in place that allows that to happen. Unless it's a second filing on a case that's already open, CASA is not involved until later on. Probably the next hearing or 2 hearings down the road is where CASAs will start to show up for court and start to get involved in cases, but generally not at shelter hearing. But you do receive copies of the petitions and you get the information as to why the case was filed. So at the shelter hearing, in addition to having attorneys appointed, the other things that end up happening are the parents can be advised of what their rights and obligations are. The goal of these cases, once a case is filed in court, obviously return home is mandated by law. That is the primary goal if children have been removed from the home, is we are all obligated to work towards reunification. That's what we're required to do. Whether everybody believes that it's a good idea or not, that's what the law requires us to do. So parents are given an opportunity to do things in order to get their kids returned. And they do that through a treatment plan. And in order to get a treatment plan in place, the court has to have the authority to order that the parents do specific things. At a shelter hearing, the court can order protective orders. They can order only supervised contact. They can order that someone get UAs. They can order no contact with a specific person, but they can't order treatment at a shelter hearing or early in a case. There has to be what's called an adjudication. And that's the court making a specific finding that the children are dependent or neglected. Excuse me. So generally, in the large majority of our cases, parents end up admitting to the petition, it's called. They admit to the court that their child is dependent or neglected and that they need services and the help of the court and the help of the department. So that's generally what happens. That's the majority of our cases. Into the 90th percentile of our cases are handled through an admission. The other 8%, we'll say, can be taken to trial. Parents are advised that they have the right to have a trial, and they can have a jury trial and force us as the county attorneys to put on evidence that proves the case. So they can do that as well. It doesn't happen all that often, but it does happen. And we will have cases that we try to a jury of 6 people and present evidence as to why we believe these children are dependent or neglected. So once there's an adjudication, then the court can order what's called a treatment plan. So at the shelter hearing, for the most part, parents will enter admissions to the petition, which means they will admit to one of the 6 categories, I think there's 6 categories or definitions that the law provides as to why a child's dependent or neglected. And it's anywhere from that the child is actually abused or the parent has allowed another to abuse the child, to a provision that says the child's beyond the control of the parent and has run away and is beyond control of the parent. Generally, it's somewhere in between where children are determined to be in an injurious environment, or what you'll hear in court is what's called the no-fault provision. And there's a provision of that section of the law that says a child's dependent or neglected because they're not in the custody of or domiciled or without proper care through no fault of the parent. That is sometimes hard to reconcile with what the facts of the case are. I mean, clearly there is some sort of responsibility of the parent, but the goal of these cases is to get to a treatment plan. It's not about guilt or innocence. That's in a different court. There may be concurrent criminal charges in some of these cases, and that's where guilt or innocence and potential jail time, probation, those kinds of things come out of. These cases are designed to try and fix, as best as possible, the issues that brought the case before the court. So if we're talking about a substance abuse and a mental health issue case, there may not be criminal charges. There may not be some specific incident of a broken bone or bruises on the child, but it's more of an injurious environment. It's the neglectful environment that children have had to live in for the last 5 years of their lives because their parent uses methamphetamines, drinks too much alcohol, there's domestic violence. So we want to get to a point where those issues are being addressed. So we want to get to an adjudication. That's why any kind of admission to the petition is agreeable to us and thankfully to the court, so that we can get to the treatment plan, which is what the meat of the case is about. We want to help these families get these kids back. So at shelter hearing, a good number, a large percentage of our cases, there will be an admission to the petition at the shelter hearing. If not at the shelter hearing, and particularly in the weird circumstance we live in now, cases will be set over for a week or two for what's called either further advisement or a pretrial conference. And the same thing happens at that hearing. That gives parents an opportunity to meet with attorneys and discuss the case with them and get a better understanding of what their rights are, and to sort of let the dramatic and traumatic situation of having their kids removed and having to come into court settle a little bit so that they can make some decisions as to what's best for them and their family. So at the early stages, it's either the shelter hearing or a pretrial conference. There will be an admission to the petition in the large majority of our cases. If a case goes to trial, that goes kind of a different route, and the time frames change in terms of how all this is supposed to happen. So as I talked about earlier, we have to get into court within certain time frames if we have a judge's hold or if we have a police hold. There are also mandatory time frames in terms of when we hold hearings and the different types of hearings. There's what's called the expedited permanency planning provision of the law. So in a family where a child's been removed or children have been removed, and any of those children are under 6 years old, then that becomes an EPP case, an expedited permanency planning case. You will hear that referred to as EPP. And EPP provides guidelines that direct the court as to when things are supposed to happen. And essentially it says that if a child's been removed from their biological parent, they are to be in a permanent home within 12 months of that removal if they are 6 or under. That 12 months is a fairly short period of time when you're talking about the kind of issues that we have to address. When you're talking about needing to deal with chronic mental health issues, long-term substance abuse issues, those kinds of chronic, difficult issues to deal with, 12 months is not a very long period of time. And oftentimes, there will be delays at the front end of a case, either because of the adjudication part of it or because of the, I'm sorry, for some reason my nose is itchy today, or because they are slow getting started with their services, and that 12 months now becomes 10 months or 9 months, and it becomes shorter and shorter. EPP says 12 months. Adams and Broomfield County also have, as required by the Supreme Court, have guidelines that they developed in terms of how they handle cases. And they have essentially said 12 months should be the guideline for every single case, not just for cases with kids that are 6 or under 6. So we try and get cases moving into permanency within a 12-month period of time. We're not particularly successful at doing that. I don't know what the percentages are, but I know that cases are not, they're certainly not closing at 12 months. I think we do get kids into permanent homes within that period of time, but they're not closing, they stay open. I haven't seen the numbers recently, but I know in the past it was in the 90 percentile range that we were getting kids into permanent homes within that time frame. But generally it's 14 to 15 months that a case will be in the court system, or longer. We're now having cases that are taking longer, and there's various reasons for that. but we're back to having some cases that have been in the system for 2 years, 2+ years, as we're trying to resolve the issues and figure out where kids should go and whether parents' rights should be maintained or not maintained. So cases have, I think that the cases have changed a little bit in terms of how long they take. I think the other issue that everybody in the field has talked about is that cases seem harder. And when I mean harder, I mean they're multi-symptom kinds of cases. It's not just someone's drinking too much alcohol. It's mental health, alcohol, domestic violence, homelessness, general poverty, all of those things combined, or any combination of all of those things. And those make cases harder. Resources are less available as funding changes and people get out of the business. There aren't as many substance abuse treatment providers as there used to be. And so those things are all impacting how long cases stay in the system. And I think that there's also sort of a consensus that people are angrier and less willing to comply with the government and not wanting to do what's asked or acknowledge what's going on. And it doesn't matter that their children are impacted by it. It matters in terms of what their views are and what their view of the court and the system is. As you can imagine, Human Services is not the most popular government agency out there when it comes to removing children. Words like snatched, stolen, taken, kidnapped are often used to describe what Human Services does, none of which are accurate. So I saw a question in terms of the difference between capacity of a foster home and a group home. I don't know the specific numbers, but I know that foster homes are generally around 4, maybe 5 kids. If they're sibling groups, it can be around 5 kids. If they're not sibling groups, I think it's limited to a little less than that. And group homes go up to a different level from there, and I don't know what the maximum of a group home is. And then there was another question somebody just put up that I missed. And I'll see if I can get it back up. What happens if the adjudication is not a civil issue but a criminal issue? Those cases handled separately. So generally what happens in that situation, all of the dependency and neglect cases are civil cases. There is no criminal consequence. The standard of proof is not a criminal standard of proof of beyond a reasonable doubt. The criminal case is a separate case. It can run concurrently and at the same time as a D&N case, but it's not the same thing. So there's no if or are they in civil or are they in criminal. They are in civil for the dependency and neglect case. The cases that you are on are considered civil cases. That doesn't mean that there isn't a criminal case also in existence where kids may have to testify, where parents are charged with specific crimes. That may be happening at the same time. Those cases always run slower than our dependency case. So they connect just in terms of what the facts are and the impact on the children, but they don't connect in terms of legal issues. So hopefully that answered your question. So once we have an adjudication in a case, we're required to put in a treatment plan. And as I said, that's sort of the spine, that's the framework of a case in order to try and get kids back is the treatment plan. It is one of the things that has changed in the child welfare field over the last 10 years is the real strong push for greater family engagement. So Adams County and Broomfield County have what they call family team meetings. You will come into a case generally after adjudication, and you'll start getting involved. You may participate and will likely participate in family team meetings further on through the case. But initially, there are family team meetings that take place in all of the court cases, and they ideally are taking place within, I believe it's within 72 hours of the case being filed, sometimes before it's filed, sometimes immediately after it's filed. So at that family team meeting, parents are there. They try and encourage them to bring whatever supports they may have, whether that's kin, whether that's clergy, whether that's family friends, if they have treatment providers, et cetera, then they come to that family team meeting, the issues are discussed, and the parents participate in talking about what kind of services they believe would be helpful. What do they think would be good for them? Are they able to work with that? Do they know what's going on? And can they address the issues that they believe that they have? And that becomes the basis of the treatment plan, is those kinds of discussions. And of course, the treatment plan's designed to address domestic violence, if that's an issue, mental health, substance abuse, parenting education, if that's an issue that's presented itself. And treatment plans are dynamic documents. They change based upon the circumstances of the case. They may be, right now, they may contain some specific parenting education or specific life skills kinds of assistance. But if after the parents have gotten sober and they're actually staying sober, it turns out they know how to parent, they just weren't able to do it because they were always drunk or high, then you may remove that issue of parenting education because they clearly know how to parent, they just weren't able to accomplish it. So it can change on a regular basis based upon either new issues that present themselves or issues that initially you thought were issues that really are not. And that treatment plan can change on a regular basis. But essentially, it's a court-ordered plan to address the issues that brought the case before the court. And that's the hope, is that it will address those issues. And the court has to find that it's appropriate, generally that it's capable of success, that it's in the best interests of the child and the family, and then they will order it as a court order. That happens at what's called the dispositional hearing. And the dispositional hearing is required to be held 30 days after the adjudication, unless you can do it at the same time. So if a case gets set for trial, you can often do it at the same time because the case has been around for 60 days before the trial takes place, so you have a pretty good idea of what your treatment plan is going to be. But if they admit at a shelter hearing, then it will get set over for 30 days for dispositional hearing. Generally, that would be the first hearing that you folks would come to, would be the dispositional hearing. Treatment plan gets ordered, visitation gets ordered, and established both at the shelter hearing and then reconfirmed at the dispositional hearing. Custody is addressed and can be addressed at every hearing. Visitation can be addressed at every hearing. So you try and figure out those kinds of issues. And the court will often give discretion to the department and the guardian ad litem to make decisions around changing, expanding visitation, to make decisions around custody. If we're investigating a particular relative, say an aunt, that we want to look at as a potential placement for those kids, the department has to do background checks, get fingerprints, do a home study to make sure that that's an appropriate place and a safe place, because clearly you don't want to move them from one abusive environment into another. So you want to make sure that that's an appropriate place to put them. And we can have discretion to place there without having to come back into court. And that happens in almost every case. And the same issue with visitation. If you can come up with a different form of visitation, if you can find a family friend or relative who can supervise visits, that might be appropriate, and you don't need to come back into court to make those changes. So that's what will happen at a dispositional hearing. The parents are advised and inquired of as to their understanding of the treatment plan. Questions are answered, and then they move on with getting that treatment going and starting to make some changes. The next hearing after dispositional hearing is what's called a permanency planning hearing. And this is where there's a difference in what Adams and Broomfield counties do versus what the law says. We can have shorter time frames for things than what the law requires. We can't extend it. So for EPP cases, for kids that are under 6, the court is required to have a permanency planning hearing at 6 months into the case. For kids that are over 6, it can be at 9 months into the case. Our judicial district has determined that we want permanency planning to take place with the court earlier in a case than 6 months or 9 months. Parents need to know what consequences there are, what they're working towards, and how they get there early in a case rather than wait 9 months and now you're looking at termination of parental rights and they never really understood the seriousness of that. So the idea is to keep them informed over that period of time so that they know what potential consequences there are. They're advised of what that is, but it's put down as a permanent plan. And generally, if you look at the time frames, they'll have a shelter hearing 72 hours after a judge's hold. They'll do an admission. There'll be a dispo 30 days later, and permanency planning hearings is 60 days after that. So you're essentially 90 days into a case. And we're saying to the court and to the parents, this is what the permanent plan is for these children. Now, the majority of the time, that's going to be return home. But there may be situations where it's going to be a concurrent plan, where it's return home. It might be return home and permanent placement with a relative, or return home and adoption. And the reason it's a concurrent plan is you're not going to have a concurrent plan with a family that the department and the court has no experience with. But unfortunately, we have frequent flyers where we'll have families that come in for each of their kids, or you file another case because the first case didn't last. They got their kids back, they start using drugs again, they start with the same issues they had before, and we file a second case, or a third case, or a fourth case. And now the permanent plan is going to be different. We have to say, okay, we're going to try and return these kids home again, or they have a new kid. We're going to try and return these kids home, but we also recognize that you haven't been very successful in the past, so we have to have a plan B. And if you follow your treatment plan and do what's required, then plan A will be return home. But if you don't do that, as you haven't seemed to be able to, then plan B is going to be an alternative to return home, a different permanent plan. So we try and identify that early in a case. And the permanent plan can change throughout a case based upon what the circumstances are in a case. So it also is fluid. It's one of the things that I've always told all the attorneys that have come through our office that we work with, is that these cases are relatively flexible. There's nothing written in stone in these cases except trying to figure out the best interests of the child. So everything can change. And the good news with that is that there also is, if there are mistakes made in a case legally, if something isn't done or something is done and you need to fix that, then you have the ability to do that in these cases much more easily than you do, say, in a criminal case. So at 60 days after disposition, we have the permanency planning hearing. We review what's going on in the case, how they're doing with their treatment plan. Are they providing UAs? Are they going to their substance abuse treatment? Are they doing what they need to do? Are you guys hearing the chainsaw? Am I blocking out the chainsaw that's going on next to me? Okay, good.
Hey, Howard, we did have a question
I'm
about
trying
the
to,
timeline for the EPP. Is that found in the children's code?
it is, although it also is in our district plan, the document that we've developed over the years and modify over the years. The timeframes for Adams and Broomfield County are going to be more specific in the district plan, but the general timeframes of expedited permanency is in the statute. And for all of you who don't know, the Children's Code is contained in Title 19 of the Colorado Revised Statutes, and it deals with all of the children issues. Dependency, neglect, delinquency, relinquishment and adoption, parent paternity cases, and some child support laws are all contained within the Children's Code.
Thank you.
Was there another question I missed?
There was.
There's a question about shortage of foster homes available in Colorado. Occasionally, kids will be sent out of state. Generally, it's to residential treatment facilities. We don't use foster homes out of state unless it's a relative. And we don't generally use group homes out of state. There is a shortage, but things get figured out. But there are some kids, usually adolescents, who have ended up out of state because of the issues that they present, and there's no appropriate placement provisions for them in Colorado. But we really, really, really try to avoid that for obvious reasons. There just is no good way to maintain kids out of state. Okay, so we've done the permanency planning hearing. You folks are participating at that point. Clearly, that would generally be the latest place that you come into a case, but occasionally someone will ask for a CASA volunteer to be appointed on a case later. But for the most part, you come in around disposition or permanency planning or somewhere in between. And your staff makes the decisions as to when and how and who to appoint or to assign to different cases, and we don't have any involvement with that. We end up just working with whoever ends up being the CASA volunteer, like even Rachel we end up having to work with. Even though we've asked not to time after time after time, but we still get stuck with her. Just kidding, of course. But so that's how things work. You write reports, you get involved in family team meetings, you will sometimes attend staffings involving your kids. How you do your jobs and what your requirements are come from your staff and your rules and your regulations. But you work closely often with the caseworker. You will work closely in some cases with the guardian ad litem. And unfortunately, you will also find hostility in cases from parents' attorneys, sometimes from guardians ad litem. And hopefully not from caseworkers. I would like to believe that everybody has sort of, over the last almost 20 years, people have finally gotten used to the idea of CASA volunteers in a case. But there's also the other players that have come into these cases over the last couple of years is parents' attorneys now have the ability to have their own social workers work on a case and try and assist the parents specifically with obtaining services and sort of monitoring what the department does. And so they can get involved. And most of the time they're appropriate and they're pretty good. But everybody involved in this kind of work will occasionally either encounter or experience themselves some boundary issues. These are difficult and emotional cases. And in this training, I end up at this point at some place in the training that the circumstances of these families are thankfully and generally not the circumstances that we experience, that our lives are not as chaotic, that our lives are not as troubled, that hopefully all of you have been screened enough that you don't have ongoing methamphetamine problems, that you don't have consistent criminal cases that get filed, that you don't have a lot of domestic violence. That doesn't mean you don't have some experience with that, unfortunately, but at this stage in your life, that's not an issue for any of you. If it is, then that's something that your staff needs to address. But what's often difficult in these cases for all of us is that we will often place our own values, sort of have a transference of our own values and our own parenting expectations onto the families that we're dealing with. And we run into some boundary issues around doing some of that. I don't, because I'm cynical and I don't like children, so I don't have to worry about it. But you guys are all still idealistic and thoughtful and caring about kids, so you run into those kinds of problems much more so than I do at this stage in my career. But nevertheless, it's something to really be aware of. And I know your staff helps with that and they're aware of it, but it's something that you internally need to remain aware of as well, that these are not your families. They may not have the same idea of parenting that you have, and we don't want to get them. Our goal is not to get them to what our ideal parent is. Our goal is to get them to be a safe parent, because children are always better off with family and with parents if it's safe. It may not be ideal. They might always be marginal, but they're still the parent, and that's still where kids should be. And marginal parents raise perfectly functional members of society all of the time. And so our goal is not to overcome and make them ideal parents or parents that meet our specific standards, but to make them safe and appropriate parents. That's what we try and do. So there is that conflict that comes up in these cases where your expectation might be way different from what that family's reality is going to be. And you have to be aware of that and just be cautious about that impacting how you approach children, how you approach the court, how you deal with families. And it's the same thing for caseworkers. It's the same thing for social workers who work for parent attorneys. I mean, that's an issue that just comes up in this type of work, because the reality is that everyone who does this are caring and hopeful and optimistic and want to see children get the best they can get. But that may not always be, your best may not be what the family is capable of reaching. So just something to keep in mind as you do this work. Your staff are certainly familiar with that. You're mentoring CASA volunteers who have done this, the veterans. They certainly, I'm sure, have experienced it and are familiar with it, and it's something that they're aware of. So that's my sort of soapboxy lecture at this point. I may come across something else as we go along, but that's where we are. So we've adopted a treatment plan. We've gone through permanency planning. We're now reviewing the case essentially every 60 to 90 days, unless it's a pretty complicated case, and then we'll come into court more often. Most of the cases stay in the magistrate's division, but cases will move to a judge's division when they get to be more complicated, when there get to be more contested kinds of issues. And it can be anything from placement, custody, to visitation, to whether treatment provisions and treatment plans accommodate people with developmental disabilities, There can be all kinds of reasons to have contested issues. But we review the treatment plan, we review those issues on an ongoing basis. The cases that parents jump on their treatment plan, start doing things quickly, start making progress, we try not to keep kids out of the home for any longer than we absolutely have to. And we can continue, and the court will continue to supervise families after kids are returned home in those kinds of cases, so at least for a few months, to make sure that it sort of sticks and that the kids are okay. But then we have the cases where parents don't do their treatment plan, or they're pretty sporadic about doing that. They're inconsistent about what they do. Unfortunately, the outcomes of those cases are different. And if we have appropriate kin, it might be that we're able to give an allocation of parental responsibilities to that appropriate kin. But if we don't, or even if we do have appropriate kin, it may be determined that the best interest of the child is served by termination of parental rights. And we don't do that in even 10% of the cases that we file. It sometimes feels that way because everybody pays attention, just like you do in everything. You pay attention to the worst circumstances and don't pay much attention to the success stories. Everything on the news is ugly. You don't hear a lot of the good news, which is the majority of what happens in our world. But it's the same thing in these cases. Everybody focuses on the bad cases and doesn't pay much attention to the successful cases. But a termination of parental rights often comes up as something that happens in a case. Parents can't deal with their substance abuse issues. They choose not to separate from the domestic violence partner and continue to have violence as an issue in their home. They have ongoing mental health issues that aren't going to be resolved in a time that the child can wait for. So we file a separate motion for termination of parental rights after we've gone through a case for a while. We will generally not file those motions in a case until we're close to a year into a case, depending on the circumstances. Now, clearly, if the parents have just bailed and they're not coming to court and they're not staying in contact and they're not having visitation, the case may move to termination earlier than that. But for cases where they're even marginal and they show up to some visitations and they keep coming back in and say, I need a new referral for substance abuse treatment, and they'll go in and they'll get 3 UAs in a row and then they disappear again. Or they'll go to 3 treatment sessions and then they disappear again. Those are the kind of cases where we still try and hold out hope. And that's really what these cases are about, is having hope that people will be able to learn, will be able to address their problems, and will be able to move forward to where they don't need the involvement of human services and the court. And it's harder to do on video, but I'll try and do it. When I talk about being cynical, and it's true, I am. And 30 plus years of this work gets you there, and I may have even started there. I don't know. It's too long ago to remember, but I certainly am there now. But that doesn't mean that I don't still have hope that a treatment plan can help a family, and that human services and the court involvement can actually help some children and save some children. And I have hope that a family is going to pull it together. And it may be that we've seen them 3 times, but this might be the one. This might be the filing and the case that gets their attention and gets them to really take this seriously. And sometimes that's true. So the way I've always described it, and you can't see it as well, but my arms are out extended. When I started this work, this is how much hope I had. By the time I've done it over 30 years, it starts to get to here. And if it ever gets to here, that's when I have to stop. But so far, I still have at least this much. And that's how you keep going in this stuff. Otherwise you can't do it. If you don't believe that it's going to help, then there's no reason to be in the business or a volunteer. So anyway, that's my other little spiel. So when we get to termination of parental rights, there are things that we have to prove to people or to the court. There's a criteria in the law about what we have to prove to the court. So in order for the court to grant a termination of parental rights, there has to be a treatment plan, there has to be an adjudication, there has to be a treatment plan in place, there has to be, the court has to find that the treatment plan was either not complied with or not successful. The court has to find, and we have to prove that the parent is unfit, which means they're not able to provide the appropriate environment, nurturing, and proper care for their child, and that the treatment plan has not been able to get them to a place where they can do that. You have to show that a reasonable period of time, based upon a child's perspective, is not likely to make them become a fit parent. And you have to show that there are no less drastic alternatives to termination, which would be permanent placement with a relative, something like that. And you have to show it's in the best interest of the child, based upon the child's needs to have their rights terminated. So those are all the things that we have to prove. A termination can be anywhere from a 1-hour hearing with parents who have not done anything to a 4-day hearing with parents who keep trying to do some things but are never really cross the line and never really get there. We have to put on evidence. We have to bring in treatment providers to indicate that they have been inconsistent in their treatment, that they've attended their groups, but they haven't really participated. Excuse me. We have to show through visitation supervisors that their relationship is not, their visitation has been inconsistent, or when they visit, they're not able to set boundaries, they're not able to pay attention to all of their kids at the same time. Whatever the issue is, there may be psychological evaluations done for parents. There may be parent-child interactional evaluations done, and we bring in the people to talk about those evaluations. And if a parent, Jean is asking, if a parent goes AWOL, that's what I'm talking about when I say that they're not communicating, they're not doing anything on their treatment plan. They have essentially abandoned their child or children. They don't communicate with the department. They don't come to court. Their parental rights in those circumstances are likely to be terminated because we have their kids in custody, and they've pretty much said, we're not going to play. We're not going to participate in this. We care more about being in this domestic violence relationship than we do about our children. It's more important to continue to use substances than it is to get our children back. We don't understand. We're angry. We're not going to play. We're not going to do anything you ask us to do, and we're not going to do this. And there are lots of families, not lots. I mean, when I say lots, I mean in percentage of the termination cases we have, where parents will come in and confess the motion to terminate because they recognize that they have not done anything and they recognize what's actually in their child's best interest. So they have that moment of, yes, I'm going to do the right thing for my kids. There are often parents who don't appear at their termination hearings. And I always believe, and even though I don't know this for a fact, but I always believe that that's their way of basically saying, remaining to be angry at the system and be able to tell anybody that they know is that social services, the law took my children and never gave me a chance to get them back. But the reality is that they never participated, they never did anything, and they refused to come to court. So they are making those choices, but it allows them to transfer blame onto somebody else and make it somebody else's fault, which is often what happens.
Howard, I
So the
think we
really
have.
seriously, go ahead.
Oh, sorry. No, there's another question from Mara regarding special respondents at the termination stage. Did you see that question?
Oh, okay, let's see. Yes, they generally are, unless they're the specific placement and they're going to be the adoptive home, they are taken off the case once termination happens. Termination, rights of relatives, which is usually special respondents, those rights flow through the parents' rights. So even a grandparent's rights in regard to a grandchild flows through the parents' rights. So if the parents' rights are lost or terminated, then the grandparents' rights are lost or terminated as well. And they don't have additional rights as a grandparent once a termination takes place. Now, if a grandparent ends up being the adoptive home, that's a different circumstance. But then they become the adoptive parent, so now they're actually a parent, not a grandparent, if the adoption goes through. So special respondents, which are usually kin who have custody of kids or are involved as a support system for the family, their acknowledgement as a special respondent ends once the case ends, or once the termination happens, if they're not the specific placement. Did that answer your question, Mara? I hope. Any other questions? I know I'm moving through this stuff generally faster than I do when I'm in person. Okay. So at the termination, the court makes the decision based upon and makes specific findings, as I just talked about, and makes a decision based upon the child's best interest. And they look at the child's emotional, mental, and physical needs. And they pretty much make a decision that says these parents are not able to meet those needs, or the circumstances that brought the case before the court initially have not changed. They have not improved. They have not been able to demonstrate that they can be safe and appropriate parents for these kids. And there's specific language about that I don't have in front of me, so it's essentially what I'm talking about. But at the termination hearing, you guys have been involved. You have provided information to the court. You provide reports at each of the review hearings. You've had one-on-one contact with these children for a significant period of time. And I know in some counties and with some county attorneys' offices, they will actually call CASA volunteers as witnesses. We do not, unless you absolutely have to. Terminations are only to the court. There are no juries for terminations. And I missed who asked that question, but I saw the question. So it's only a court trial. It's not a jury trial, which is a good thing, because I don't think you're going to ever be able to convince. I think it's harder to convince people to terminate parental rights. And judges will say this, that it's harder to convince people that to terminate parental rights than it would be to find them guilty in a homicide case. Because it's a different issue and it's a different standard, and it's way more of a, it's less factual. There's more emotion involved, and there's more nuance and kind of gray areas involved in these kinds of cases. So thankfully, I know some states have juries, but Adams County does not. Or Colorado does not, excuse me.
Or there was another question about placement. What are the rules around splitting kids up into separate foster or adoptions?
There's what's called a presumption, which is a legal term, but it's that you are supposed to try and keep sibling groups together. And the only reason that you can't keep or shouldn't or won't keep sibling groups together are safety reasons. I mean, there clearly are sibling incest or sibling abuse cases where you can't have kids together. Or you have circumstances where one child needs specific needs met, special needs met, um, versus some of the other children, and they may have to have a separate placement for that. Or unfortunately, at least for short-term purposes, there aren't, if you have, say, a large sibling group, there may not be a placement where all of those kids can go together, but the department continues to work to try and find that placement where they can be placed together. But the first responsibility is to try and keep siblings together. That's the first thing that the department is required to do. And if that can't be done, then they'll get separated as needed. And there might be a difference that, you know, there's an infant and a 18-month-old, and then there's an 8 and a 10-year-old. They may have different needs that, you know, it may require different kinds of placements. So those kinds of decisions are made on a case-by-case basis, but they really work hard to try and maintain sibling groups like they're required to. Any other questions? Did I miss anything? Okay, splitting up kids. All right. So again, the termination, there's lots of issues that can come up. There can be lots of testimony that comes up. But the reality is that we try not to get there. We try and come up with alternatives. The department really works hard to maintain families together, even if it's with extended family, so that parents can maintain their contacts and still be involved. And, you know, the ideal circumstance is if you have parents, say, that are developmentally disabled and they want to parent their child, but they can't, they just don't function at a high enough level. If you can find the appropriate relative who can take those kids and still maintain relationships with the parents, but the kids are in a safe, appropriate home, that can be, you know, that ends up being a good circumstance for everyone. But there are circumstances where we have to just terminate parental rights, where parents have just indicated through their behavior that they will not parent and they will not comply with whatever the court asks them to comply with. Once termination happens, then the next stage is finalizing permanency, essentially. Once the court orders termination, one of the things that's really changed over the last 5 years is the appeal process. Parents have the right to appeal the decision of the court regarding termination, and they can basically come in and say, the court made these kinds of mistakes. There wasn't enough evidence to show termination was appropriate. I had an ineffective attorney, so that affected the termination. They can appeal for any number of reasons. And that goes to the Court of Appeals. And then sometimes it will even go up to the Supreme Court of Colorado, but generally not. Unfortunately, those appeals take a long time. They're supposed to take less than a year, but oftentimes they will take well more than a year for the Court of Appeals to make decisions. And the majority of the time, the Court of Appeals will support what the trial court did, but it takes a long time to get there. So what ends up happening is that the children aren't freed for adoption until that appeal runs its course. So kids, hopefully, are in their permanent home, are in their adoptive placement, and are able to remain there through the appeal process. It just slows everything down in terms of the legal finalization for kids and families. So that can add another 9 months to a year or even more to a case before the adoption can take place. But after you go through that process, then kids are available for adoption. They You would think with all the talking that I do that I don't get hoarse, but I do. Clearly. So sorry about that. But once all of that, the legal process is finished, then kids are adopted. There's the adoption hearings. If we ever get back to live hearings in court, are some of the nicest things that happen in a court. Judges love to do adoptions. You guys have been involved up to that point. You remain involved through the appeal process until the case actually closes, and that's when your appointment terminates. And I know that there are plenty of CASA volunteers who end up maintaining relationships or contacts with families, and hopefully that's done in an appropriate way, but that's what happens. During an appeal termination, yes, when the court orders termination, guardianship will go to the department, and the department is given the right to consent to adoption. Custody may be with a relative. If the children are placed with kin, and that's going to be the adoptive home, then legal and physical custody will be with that kin family, but guardianship will be with the department. If kids are in a foster home that's an adoptive home, then legal and physical custody and guardianship remains with the department. And that goes on through the termination and through the appeal process until there's finalization. The department helps with the yes.
I go ahead and finish, sorry.
I was going to say the department helps families with the adoption process, with the filing of the petition, with the investigation of the home. They have to pass an adoption home study and be approved for that. They have to go through fingerprint checks and FBI background checks. So they have to be proven and appropriate to be an adoptive home. So the department will be involved with that. Question?
There was an ICWA question that popped up on the chat from Cheryl.
Yes, we haven't talked about ICWA. ICWA is the Indian Child Welfare Act. And the Indian Child Welfare Act was created in, I believe it was 1978, which was designed to address the issue of separation of Indian children from their family and from their tribe. And the push that happened through all of the 20th century, essentially, to assimilate Indian children into non-Indian homes and to essentially destroy their heritage and their background and force them into these boarding schools. There's a lot of books and movies and documentaries out there about that process. So the Indian Child Welfare Act was passed by Congress and is the law across the country, and all of the states are required to comply with it. And what ICWA says is that at every stage of the case, the court is to inquire of the parent whether they have Native American heritage, essentially. And the county attorney's office is required to give notice to any identified tribe. If someone says maybe, I think my grandmother was a member of the Pawnee tribe, then notice needs to go to the various branches of the Pawnee tribe to find out if anybody was on the rolls and whether a child is a member or eligible for membership in a Native American tribe. And if they are, then that becomes an Indian Child Welfare Act case. What that does is that places different requirements on parents or on the court and on the attorneys to prove a case at a higher standard of proof. It requires the court to mandate a specific triage of placements that are appropriate under the Indian Child Welfare Act. So the triage of appropriate placements are immediate family, extended family, and that includes if only one member of the family is a member eligible for membership in a tribe and the child is determined to be eligible for membership. If the mom is Native American but the dad is not, you can place with the dad or the dad's side of the family, and that's considered appropriate under the Indian Child Welfare Act. But you place with family. If you can't find family, then you're required to investigate and try and find placement with a member of that family's tribe. And if you can't do that, then you need to look for any Native American home to place a child with. And then finally, if you can't find any of those things, then the tribe has to approve placement in foster home, group home, whatever kind of home that you end up having to place those children in. The tribe remains involved in the case. Once it's been determined that it is an ICWA case, the tribe remains involved, or at least you try and keep them involved, and some tribes are more active than others. Adams County has developed a specific specialized ICWA court. Judge Delgado supervises and runs an ICWA court, which is specifically designed to address these Indian child welfare issues, and is held generally in the old days. It was held generally every other Tuesday afternoon. I think the schedule fluctuates a little bit right now, but they contact the tribe. They have these specific cases. They have specific caseworkers that work those kinds of cases, so they have familiarity with the tribes. We have a legal assistant specifically designated to do all of our ICWA cases. She sends out all of the notices. She has developed contacts at all of the majority of at least the larger tribes that are often involved. And so we provide those notices. We work with the tribe. The tribe tries to work with our department and with our court to make sure that services are consistent and compliant with the Indian Child Welfare Act. If we end up having to go to termination of parental rights in an ICWA case, the tribe essentially has to approve that, and we have to prove the case beyond a reasonable doubt, which is the highest legal standard. That's a criminal legal standard of beyond a reasonable doubt. For non-Indian cases, we have to prove a case by clear and convincing evidence, which is more likely than not. So it raises the legal standards of what you have to show to the court. You have to have qualified Indian experts to testify at ICWA cases that go to termination, and they have to testify that things like chronic methamphetamine use is not an Indian heritage issue. It's not something that's part of that tribe's heritage. And that it's appropriate for the child to have the rights terminated from that Indian tribe or from those parents. They don't, I believe, lose their Indian heritage as a result of that if they are members, but you still can terminate parental rights of those children. Any other questions that have come up? I do, I know that the veterans in the class here can tell you that I ran through that probably as quickly as I ever have. I'm usually scrambling at the end and running out of time. And I think that comes from not having that face-to-face interaction with you guys, which is a much more fun, I think, a much more fun way to present this information. Rachel and Vicky are there shaking their heads no, but I don't really believe that. I think it's more fun.
There was a question
so any
on
other questions?
Yeah, there was one that popped up on the chat during an appealed termination. I think you answered that. Sorry. Ignore me.
Yeah.
Okay.
Yeah, that's okay. Anybody else have any questions, concerns, things I can help with? I know it's a very strange time. It's probably a very strange time for you folks as well. I don't know what your policies and rules are now in terms of visiting homes and visiting children face to face, or if you're doing things virtually. Things, if you haven't heard, Human Services is going to be opening their buildings for limited use beginning next Tuesday. I don't believe they're setting up visitation and in-person family team meetings yet, but they are going to be opening the building in a very limited, restrictive way so people can get back in there, get some services, start getting things done a little bit more. And they're having limited staff come back into the building to start working there as well. And then that includes expanding home visits and in-person, face-to-face kinds of meetings. Hopefully that'll impact visitation as well. Okay, so I see a couple of questions that have come up. In terms of the consequences of the admission, and this is a good question that oftentimes comes up because it's hard to understand a no-fault admission. In these cases, the consequences is kind of not the appropriate term. As I said, the goal of these cases is to get to a treatment plan to address the issues. So there's no difference between the adjudications. So if the adjudication, you go to jury trial and the jury determines that the child is dependent and neglected because the parents did not provide proper parental care, or physically abused or allowed someone else to abuse their child, that still carries the same consequence in terms of getting to a treatment plan as any sort of admission does, including the no-fault admission. So the consequence, ideally, or realistically, is a treatment plan, an adjudication and a treatment plan. Now, at some point, that what happens in these cases is that if a case is founded by the department, that's different from an adjudication. That's a statewide, essentially registry through the TRAIL system that indicates that someone has a founded abuse and neglect case for injurious environment. That might impact that person's ability to get a job at a daycare center or to get a teaching position or something like that, because that's something that a background check's going to turn up for those kinds of positions. But it's not going to turn up for somebody who wants to become a truck driver. So it could have a consequence that way. And then there were a couple of others. Confidentiality. That's a tough one. That's a good question. The question is, cases are confidential, yet the hearings are open to the public. And that's true. And the court legal system has determined, and it's even, I believe, in the Constitution, that that the court system is to take place publicly. That people have a right to be present, have a right to watch cases, and that includes these kinds of cases. Even though the information is confidential, the public can come in and watch. The court can make the determination in any individual case that no one's to be in the courtroom. You may encounter situations where you're in a courtroom waiting for your hearing and the court closes the courtroom for the hearing before you. Oftentimes that will be cases that deal with difficult issues like sex abuse, and the court will close the courtroom around those kinds of issues. Or in delinquency cases, it may be something like that, and the court will close the courtroom. But the presumption is that these cases, the court will remain open to the public unless the court makes a specific determination that's not appropriate in that kind of a case. I know it's a difficult concept to understand because the information is confidential, but I think the determination has been the right to have an open legal system and an open courtroom overrides the limited information that's going to come out within a court hearing. And it is fairly limited. You may hear a name but you're not going to hear addresses, you're not going to hear locations, you're not going to hear some of the specifics around a finding in a psychological evaluation, for instance. Or and anybody can request to have the courtroom closed. And then generally the court will do that. Does that answer your question on the confidentiality? I hope. Any other questions or issues or concerns? Well, for those of you that haven't started yet, good luck. Hopefully things will change a little bit to at least be a little bit more normalized. For those of you that are continuing, good luck. Hopefully you'll be able to continue doing that. Was that another question? Okay, very helpful to this one-year veteran. Thank you, Kirk. I appreciate that. And I hope it was helpful. If there's questions that come up, you certainly can. Your staff knows how to get in touch with me and how to ask those questions. If you're on a case, all of our county attorneys are able to answer questions for you. If you have some that come up, you're going to have different county attorneys on each case. So I hopefully you'll be able to get the information you need to continue to understand the process. It's not an easy process to understand. It's if you haven't had exposure to it, it's very weird and can seem really chaotic and kind of crazy, but it becomes a little bit more familiar as you do it more.